Hi, attorney Adam Diamond here with Diamond Estate Planning. In this video, I want to answer some of the most frequently asked questions about wills, trusts, and family legacy planning. Now, the first question people ask is how can I prevent my kids from getting their inheritance all at once and basically blowing it? The easiest way to control when kids inherit things and what they can use the money for is with something called a trust. A trust is an agreement for someone to hold property for the benefit of another. The property can be personal property like money, cars, or real estate. The trust also designates a person to control the property in the trust. This person is called the trustee. The trustee is in control of the property in the trust, but is to follow the instructions. When you create a trust, you can make yourself the trustee and then name someone else to take over when you pass. This means you can create clear instructions for the next person to be the trustee and telling them when your kids can have the money and what they can have it for. Some families want their children to have access to the money just for health care and education until they reach an age like 25 or 35 years old. A well-designed trust addresses this. It's like a well-packaged suitcase for a trip around the world. It can help you avoid things like your family having to go to court to settle your estate, paying unnecessary taxes, the wrong people getting your hard-earned nest egg, and your kids getting a huge check at 18 and blowing it in Vegas or a Ferrari instead of college. Also, it can protect your kids or loved ones from losing public benefits if they inherit money. Now, as you can see, a trust is a central part of a family legacy plan and can help you avoid a giant mess when something else happens to you. Another question that comes up a lot is how can I avoid being on life support? This issue can be addressed by creating and signing a document called an advance directive or living will. This document specifies when you need to be put on life support, and it basically tells your family when you want them to pull the plug. Another big thing on people's minds is what to do with their retirement accounts and life insurance policies. Now, before I answer this question, I have to give a little disclaimer. This video is not intended to provide any tax advice. I'm going to make some general statements and give you some ideas of how some families handle these things. Before you make your final decision, it is always at best to consult with a local estate planning attorney and tax planner to make sure you get specific advice for your specific situation. Now, back to my answer. Most people have retirement accounts that have some sort of tax-deferred benefit. Examples of this type of account would be an IRA or a 401k. With these types of accounts, you can designate who you want it to go to if you pass away. This is called a beneficiary designation. Most people make their spouse or partner the primary beneficiary, but in many situations there's an income tax benefit to doing it this way. Next, you'll want to designate a secondary beneficiary, and that's someone to inherit it if your spouse or partner is not around at the time of your passing. In this situation, what most people want the account to go to their children. Now, if you're okay with your kids getting all the money at once, you can just make them the secondary beneficiary of the account. But if you want more control, you can create a trust where you can control when they have access to the money. So basically, you make the trust the secondary beneficiary. You can do the same thing with your life insurance policy. But note, frequently there are different tax issues with life insurance than there are with the retirement accounts. So it's always best to walk through this plan with a local estate planning attorney and or accountant to make sure you understand these types of issues. You don't want to accidentally make a tax donation to the government after you pass. Another big thing on people's minds is what to do if someone becomes disabled. If you become disabled, would your spouse have to go to court to manage your affairs? Without the right paperwork, you'll probably need to go to court to sign their name for anything or make important healthcare decisions for them. You will need to be formally appointed as your spouse's guardian. But with the right paperwork or documents, you can avoid this expensive trip to the courthouse. Two of the most important documents are a power of attorney for healthcare and a power of attorney for property. What is a power of attorney? A power of attorney is a legal document that gives one or more persons the right to act on behalf of another person as their agent. A power of attorney for property can allow your spouse to buy, sell, refinance, or manage your property for you. If you are disabled, a properly executed power of attorney can allow your spouse to sell or refinance the house without having to go to court. A power of attorney for health care can allow your spouse to make important health care decisions for you if you're incapacitated or unable to communicate. A good family legacy plan always includes both of these documents. If you don't have a plan for your kids and your stuff, well, then the state of Illinois has one for you. If you don't do anything, a judge you don't know and without clear direction will probably decide what happens to your kids and all your stuff. A family legacy plan that contains a trust and a power of attorney documents will help you skip that expensive and public court case. It'll also save your family a lot of time and money so they can focus on celebrating your memory and your legacy. They can also skip dealing with the complicated, confusing, and expensive courthouse mess. Our team at Diamond Estate Planning is ready to help you move forward. Give us a call or go to our website and schedule a time to chat with our next available team member. Thank you.